about it. So I will leave.
I'd like to say hello to your mother. Welcome, Anita. Nice to have you here.
Mark, we broadcast in the Facebook, so probably we're going to have more people watching, but not at the Zoom platform, but in the Facebook.
Academics like audiences.
Oh,
I
yeah,
like
right.
audiences. If all of Brazil is watching, that's a wonderful thing.
Oh, great. Okay.
Okay. And I'd like to say some words introducing you, and then we should start, okay?
Let's go.
So, Professor Mark Graeber is a visiting professor of law at the Yale Law School, and the Regents Professor at the University System of Maryland. Among others, he is the author of A New Introduction to American Constitutionalism and co-editor with Professor Sanford Levinson and Mark Tushnet of Constitutional Democracy in Crisis, which I think is a very big and difficult question to answer. So, Professor Mark Graeber, thank you for joining us and accepting our invitation. The floor is with you.
Well, first, thank you very, very much. For those of you new in the business, you will discover that you will rarely have problems trying to get senior professors to speak. You will have problems trying to get them not to speak or to stop speaking, and I'm certainly no exception. One request I have in the new Zoom world, I've discovered when I speak into my computer, I speak faster than I do when I normally teach or would normally give a lecture. It seems the actual physical presence of people slows me down. And given for almost all of you, I am speaking in your second, third, or fourth language. Please, I have the chat thing open. Do not be embarrassed to put a little note, Professor Graeber, please slow down. I talk fast, even for an American, and so I appreciate it. Now, my subject is crisis and the fate of constitutional democracy. I start with a disclaimer. I have no idea whether this is the title of my talk or the title of the general program. If it's the title of my talk, I have no idea or memory whether I chose this title or whether someone said he's probably going to talk about something like that. But still, it's an appropriate title because when we think about constitutional democracy and crisis, well, it's very clear since we wrote the book, The Crisis of Constitutional Democracy, ? Another crisis has engulfed the world, and that is the crisis of COVID-19. But COVID-19 doesn't look like the constitutional crisis we've all been trained to recognize and perhaps remedy. So when it became clear COVID would be a worldwide crisis, I was asked to participate in a lot of surveys on how COVID was affecting constitutional democracy in the United States And the survey asked two kinds of questions. First, is the government using COVID as an excuse to violate fundamental rights? So sometimes in crises, the government uses it to clamp down and says we can't have communist speech, even though the crisis has nothing to do with communism. Second, I was asked about the status of the rule of law. Is the executive using the COVID crisis as an excuse to seize power? And the answer to both in the United States, and by the way, in many countries, is no, that COVID doesn't look like a certain kind of crisis of liberal, of constitutional democracy. From my perspective, and I'll get into this a little later, no fundamental rights are being systemically violated. Not to say no fundamental rights are being violated. Fundamental rights are always being violated. But the government of the United States, and most governments, I will argue, are not using COVID as a systematic excuse to violate fundamental rights. And here we might compare COVID to what happened in the United States in the wake of September 11th. On September 10th, the Republican Party was committed to dramatically limiting the freedom of people suspected of crimes and imposing the death penalty. On September 12th, they took advantage of the events of 9/11 and dramatically curtailed certain constitutional rights. None of this is really happening in the United States, and outside of a few countries, Hungary being a very notable exception. It's not happening in other countries. A second feature is COVID is not being used as an excuse to augment executive power. Every now and then, Donald Trump makes a statement saying, I can do it if I want to. It then turns out with respect to COVID, Trump doesn't want to. That a great many of us want the national government to exercise more power, not less. But there doesn't seem to be any dramatic flow of power to the national government, to the president, that is likely to be irreversible as a result of COVID. So if you were to judge COVID by the standards of the surveys that I have been given, it's not a constitutional crisis, it's a mess. But in fact, we know there's a problem. Government is not governing effectively. Government is not governing effectively in the United States. From everything I've read in Brazil, government is not governing effectively in India. Government is not governing effectively. And curiously, one of the reasons in the United States government is not governing effectively is government is refusing to put restrictions on individual behavior that medical experts deem vital to slowing and reversing the spread of COVID. I believe that is also true in Brazil. It is also true in India and a great many other countries, that our real problem is not a too powerful government, but an ineffective and too weak government, a government that is not governing. Now, this is rarely considered to be a crisis of constitutional democracy. Crisis of constitutional democracy, we've all been told, is when government governs too much, when power flows to one place, when they violate rights. But what I want to suggest to you is that effective government is at the core of the constitutional democracy project, that a breakdown of effective government is a fundamental problem of constitutional democracy, and we need to think about the tools, both for identifying breakdowns of effective government and for remedying them. So consider, just as a start, a classic expression of liberal constitutionalist ideals, the Declaration of Independence. And if there's any document people outside the United States know, it's the second paragraph of the Declaration, which if you teach it enough, you can quote by heart. All men are created equal. They are endowed by their Creator with certain inalienable rights, among them life, liberty, and the pursuit of happiness. To protect these rights, governments are instituted among men. Now I want to stop for a second, and I want people to puzzle something. Because on a certain kind of liberal constitutional theory, constitutions are about preventing government from violating rights. But there's a 100% solution to the problem of preventing government from violating rights. Don't have a government. If there is no government, government can never violate rights. But in fact, the Declaration says government is here to protect rights. The Declaration, therefore, tells us that government is supposed to do things. It's supposed to do the things that facilitate life, liberty, and the pursuit of happiness. And presumably, government is supposed to do these things well. So one of the Federalist Papers that we rarely read is Federalist 1, where Alexander Hamilton points out that a crucial element of liberty is an energetic government. We want government to do certain things, and the things we want government to do, we want government to do well. When I teach, I sometimes phrase the problem like this. All of us want a police force of some sort to have an effective police force. We have to give them some weapons. They don't have to be guns. They can be nightsticks. But they need something. And the problem of government is very simple. When we give the police officer the nightstick, how do we make sure the police officer uses the nightstick, the gun, this taser on the criminal and not on a kid who's just looking at the police officer the wrong way? How do we make sure in the United States the police officer only uses a weapon against persons who are truly a threat to the government and not disproportionately against African Americans who are just minding their own business, or if they are doing something illegal, it is not the sort of illegality that requires a violent response. And so I'd like to start, or not start, but introduce you to two documents that most people outside the United States, and indeed inside the United States, don't know, but they're crucial to understanding American constitutionalism. The first is by James Madison, The Vices of the Political System of the United States. James Madison was the person who did the most to write the Constitution of the United States and defend the underlying theory. The Vices is a document he wrote half for himself and half for his friends before attending the Constitutional Convention of 1787. And what is interesting is, what does he say are the two main vices? Vice number one is the national government doesn't have enough power. The problem is that the government under Articles of Confederation, it's not that they're violating rights right and left. They can't violate rights. They don't have the power to do anything. They can't do the things we want a national government to do because they're not authorized to do them. Second problem, the people running things in the states are stupid. Now, because of their stupidity, they sometimes violate rights, but that's not the only problem. They have no idea of finance, so they're making inflationary policies that are destroying the credit of the United States. They have no idea of foreign relationships. They're just the sort of people that shouldn't be in government. So what does Madison think a constitution is about? It's not primarily about the rights provisions. Madison was initially opposed to having a Bill of Rights in the Constitution. What he thought a constitution was about is getting the right combination of people with certain interests and capacities in government, and then empowering those people to act for the public good. So some of you may be familiar with Federalist 10. What Madison says is the way we get good government is by expanding the sphere of government. Because what happens when we expand the sphere of government is, first, we're more likely to elect fit characters. Fit characters, by the way, are people like James Madison. They're not like the people who defeated James Madison in the most recent Virginia election. But we will get people who have the capacity to understand the financial system, have the capacity to negotiate with Great Britain. Second, we will get people with a variety of interests so that no one interest can govern. So Madison said, the way you protect the freedom of religion is not by having a clause that says can't violate the freedom of religion. Because if people of one religion control the government, they will install their religion by hook or crook. What you do is you expand the size of government so there no longer is a majority religion. You have Baptists, you have Lutherans, you have Catholics, you have Episcopalians. And so at first, everyone tries to make their religion the state religion. But when the Episcopalians do that, the Lutherans, Baptists, and Catholics say no, same with the Catholics. And so everyone goes to their second best alternative. Namely, if I can't persecute, I don't want to be persecuted. So we get freedom of religion. Notice, according to Madison, we don't get freedom of religion because we have a clause that says freedom of religion. We get freedom of religion because we have a government structure that is well designed to protect the freedom of religion. We see something similar in a speech Thaddeus Stevens gave in Congress in December 1865. Now, while many Americans and people who study constitutional theory abroad have heard of James Madison, almost no one has heard of Thaddeus Stevens. I'm writing a book. Hopefully you'll all read the book and everybody afterwards will know Thaddeus Stevens is, and the royalties will be wonderful, and I'll retire and move to a palace somewhere. Thaddeus Stevens was the leader of the Republican Party in Congress when Congress passed the post-Civil War amendments, the constitutional ban on slavery, the Equal Protection Clause, the Due Process Clause, all the rights, the right of African Americans to vote. And in his speech, Thaddeus Stevens tells Congress, we have to pass an amendment. But he doesn't emphasize the amendment we all think of, an amendment concerned with rights. He doesn't spend a lot of time saying we need to pass an amendment stating that African Americans have equal rights. No, he says, we need to pass an amendment that adjusts the way Congress is staffed. Points out that under the Constitution as it existed in 1865, Southerners would get representatives for African Americans, even though African Americans didn't vote. If that happened, he pointed out, the South would dominate the Congress, they would ignore the Constitution, and African Americans would be enslaved. You needed a constitutional amendment that said, if you don't allow people to vote, they don't get represented in Congress. And what Stevens said Congress is, we then put the South in a dilemma. They don't allow African Americans to vote. They lose 30 representatives. If they lose 30 representatives, Congress will have a strong Northern majority, and we can pass lots of very good civil rights laws. They allow African Americans to vote. They get 30 representatives. The problem is 15 of those representatives are African Americans. Those African Americans join the Northern representatives, and they still pass laws that prevent discrimination against African Americans. Again, notice the assumption: a constitution doesn't work because there's a right saying no discrimination against African Americans. It works by designing a politics that guarantees a majority of people who believe you shouldn't discriminate against African Americans. So, how does all this affect our understanding of the pandemic in the United States, in Brazil, and in many other countries in the world? The problem isn't, as I've pointed out, that government is too powerful, that government is seizing power. The problem is we have a constitutional structure in the United States, and I deeply suspect you have one in Brazil, that has resulted in ineffective government, in stupid government, in politicians who hawk cures for COVID that are fake, who declare basic medical preventions like wearing a mask are unnecessary, who do not listen to people who actually know, that cannot pass laws that might be directed at the crisis. In other words, we have a constitutional structure that is not generating a political leadership class with the expertise on how to respond to a crisis, with the capacity to respond to the crisis. And by the way, we can see a variation of this in the United States with the Black Lives Matter movement. The problem, again, isn't that government is too powerful or too weak. For African Americans, the government is both too powerful and too weak. It over-polices African Americans and under-polices white persons who prey on African Americans. The problem is getting the Goldilocks moment, and Thaddeus Stevens would understand. If you have police departments with people committed to some form of white supremacy, if you have local governments unwilling to police the police departments, you will get discrimination against African Americans. The only way to limit discrimination is to devise government, not that has rules, don't discriminate, but that have people who don't want to discriminate. But now we get the last two challenges, and I have promised not to go much over my half an hour. By the way, lesson for all graduate students: it's amazing how time flies. You always feel that, my God, I don't have too much. Then you realize for your half-hour talk, what you actually had was a 4-hour oration. But I'll stick some of this in the question and answer. But we have challenges. Our framers, Madison, believed with Socrates, some people were better qualified to govern than others. We have trouble saying that in 2020. Democratic theory, in some sense, says whoever gets the majority of votes is qualified for govern, and there are no really constitutional qualifications for being president other than you win the election and be of a certain age. We might think, are there actually constitutional qualifications for being president? They may not be legal, but the constitutional system will only work if the president has those qualifications. We might talk about public interest in the same way. Madison believed there was something called the public interest that was somewhat independent of the preferences of everybody. One of the features of rational choice theory, which I suspect most of you have in utilitarianism, is increasingly the public interest is simply an aggregation of our preferences. Is there a public interest outside of that? Constitutional democracy began not simply with a commitment to protecting rights, but with an understanding that some people were better qualified to govern than others. There was a public interest, and the job of a well-structured constitution was, within a democratic system, ultimately grounded in the choices of the people, to maximize the probability that the best people, however defined, would occupy public office, and they would pursue, however defined, the public interest. Thank you very much.
Thank you, Professor. It's really nice to hear you. So I think we can have 3 questions in a row in the first round, and if we have time, we can go for another round of questions. Is that okay?
I'm here. One of the great advantages of Zoom is I'm here at your convenience. I'm an empty nester, so if we go over a little bit, I don't really care.
Okay, thank you. So, is there any questions? I have one myself.
I see, by the way, a hand from Santander.
Yes, it's true.
Guilherme.
I'm going to start. You said in the last chapter of the Constitutional Prize, Democracy in Crisis, that projects discussed in the book depend too much on constitutional law and too little on constitutional politics, and that constitutional theorists paid less attention to political foundations and ordinary politics. If I understood you correctly, I have said the same thing in different words right now. So briefly, my question is a big question. I don't know if there is an answer for that, but how to reconcile constitutional law and democratic politics nowadays? Because I think there is a tension that there was always a tension, but nowadays I think it's getting worse. And you said we need good person to government, and we need government. And we have a lot of as I understood correct, constitutional law, judiciary power, but not government property. So if you can go for a few words on that subject.
Do you want me to answer, or do you want to take a?
I think you can take 3 questions and then you answer. Is that okay?
Works for me.
Okay. Guilherme, and then Guilherme. And Vera. Guilherme and Vera.
Thank you, Professor. Professor Graeber, why there isn't many cultural depictions of James Madison in the arts, generally speaking, like Alexander Hamilton has a musical, John Adams has TV miniseries, other presidents and politicians have biopics and several movies that tell their stories, but James Madison remains studied mainly by the academics. Not, I don't think that the general audience, the general public knows much of his contributions to constitutional theory and the very foundations of the constitutional structure of the United States. Is there a reason to that we for this how can I put this? Is there a reason behind all this this absence of his portrayal? Thank you.
Vera?
Well, the U.S. Supreme Court, since the case Brown versus Board of Education, had a major role in the anti-discrimination movement or change. What I see right now is that the role of the Supreme Court concerning like the Black Lives Matter and the whole anti-discrimination movement, the Supreme Court does not have a major role anymore in this particular matter. So my question is, do you think that the role of the Supreme Court right now in the U.S. concerning the democratic constitutional structure is a minor role comparing to what the Supreme Court has done in the past?
Okay. To take the second question first, my first note was question asked to wrong member of family. I can take 30 seconds and pump my daughter, Naomi, who is a professor of music history at the University of Georgia. She'd be probably the better person to ask about why is there no Madison musical while there's a Hamilton musical. And by the way, there's a musical 1776 where Ben Franklin sings, Thomas Jefferson sings, John Adams sings. Madison is nowhere to be found. And one notion of this is simply lag. When I went to graduate school, I took a course from Professor Roger Smith, who you should invite to speak because he really is fabulous, on American political thought. And when we got to the relevant era, Professor Smith assigned lots of reading. We had about 200 pages on Jefferson, 200 pages on Alexander Hamilton, and about 10 pages on these other minor thinkers, one of whom was James Madison. And that's how people were trained throughout the 20th century. Madison got hot in the 1990s and has stayed hot, but popular culture hasn't yet caught up. Nowadays, students are being trained a lot of James Madison, and so if some of those students go into the arts and decide to write about the framing or do a play, a musical, an opera, Madison is likely to play a larger role. Now, with respect to the other two questions, to start out, I was once on a panel with the head of the National Association for Reproductive Rights, leading pro-abortion, pro-choice group in the United States. And I remember her saying, what Professor Graeber does not understand is if we lose elections, all we'll have left are the courts. Whereupon I responded, if we lose elections, we won't have the courts either. And the idea here is that all systems for selecting courts are political. Sometimes they're political in that elected officials do it. Sometimes it may be the Bar Association, but lawyers have interest. There is no neutral selection process out there. And so part of what I simply wanted to say is that no part of American politics is immune to political change. Now, one of the most substantial political changes that has taken place in American politics in the 40 years since I've been a professor, and I hate that phrase, 40 years. To me, it feels like 40 minutes. Warning, it's going to fly by. Is when I was in grad school, we were taught elites have more in common with each other than they do with the ordinary persons in their politics. So when we did surveys of elites in 1970, we discovered Republican elites were far more committed to racial equality than ordinary Republicans. Democratic elites were far more committed to racial equality than ordinary Democrats. So one thing about a court system is all you get are elites, right? People, it's almost, you have to go to Harvard or Yale Law School or maybe Stanford. Those are elites. And so if you had an elite court in 1970, it was going to be for racial equality. Now, when you do the same survey, what do you discover? Democratic elites are the people most committed to racial equality in the country, more so than ordinary Democrats. Republican elites are the people least committed to racial equality in the country. In other words, rather than the two elites being close together, they're the furthest apart. The result being it's not simply that the Warren Court are conscientious objectors in the struggle to end white supremacy in the United States, but in my view, they are active participants in the struggle to retain versions of white supremacy. Indeed, in many ways, they're doing more than the Warren Court. So there, and I apologize because I can pronounce your first name. I'm not sure I can pronounce. You mentioned Brown. One of the things we know, 10 years after Brown was decided, only 2% of children in the South were attending an integrated school when integrated was defined as it had to have one white child and one child of color. 500 white children, one white child, that's integrated. Only 2%. Schools got integrated when Congress passed the Civil Rights Act of 1964, which said if you don't integrate, you don't get any federal funds. Fast forward 50 years. In 2013, the Roberts Court declared unconstitutional a crucial feature of the Voting Rights Act. This decision enabled many southern states to impose onerous restrictions on voting. You needed an ID. You had to pay for the ID. Now, they couldn't put a restriction on voting that said no black people can vote, but they could pass restrictions that disproportionately affected persons of color. And in fact, the evidence is these restrictions are having substantial effects. So we changed the underlying constitutional politics. We changed the course of constitutional law. And thank you, by the way, to the people in chat. It is Roger Smith in the Government Department of the University of Pennsylvania, and the case citation is Shelby County versus Holder. Other
Thank you,
question?
Mark. Thank you, Mark. Stefania.
Stefania?
One moment. Thank you, Professor Graeber. It was, I can't put my video. Yes, now it's here. I'm professor at Federal University of Constitutional Law, and I'm studying a lot of the problems of a presidential system. And as you said that we have some problems with our presidents of US and of Brazil, that they don't have qualifications for being good presidents or for the constitutional system to work. I wonder if first, how to deal with these unconstitutional presidents. In our case, I can say that it's not just an illegal president because he doesn't have the qualifications, but he is anti-constitutional. He's against everything that the constitutional law and the constitutionalism defends. So the problem to deal with that, in your view, is a problem in the design of the constitutions, or it's a problem of the presidential system, as Juan Lins wrote about it. Is that the presidentialism that allows a democratic instability in your view? Or we can, with the presidential systems, we can have another kind of design to deal with this kind of presidents? Thank you, Professor.
Anyone else? No?
I'll jump in and then other people can ask questions. We probably want to distinguish between an illegal president and an unconstitutional president. So imagine Trump loses the election, Bolsonaro loses the election, and they say, I'm going to govern anyway. That's illegal. Violates the flat law of the Constitution. In the United States, the president must be 35 years old. My younger daughter doesn't qualify. If elected in 2020, and she'd be much better than the incumbent, she would be an illegal president. What I want to say, an unconstitutional president is elected according to the rules, meets the legal qualifications, but does not have the capacity to govern. Trump doesn't have the intellect necessary to understand the world around him. He doesn't have the character. Essentially, Trump is running a kleptocracy. Every decision is, can he make money on it? And these pose real challenges. How do you design a government that prevents a Trump, a Bolsonaro? And I just lost the gentleman's name in Italy that I can't quite, also begins with a B. But what's hard, yeah, Berlusconi, thank you. But what's hard is 40% of Americans think Trump is just peachy. And I suspect there is some percentage of the Brazilian population that, despite what is going on, thinks it has nothing to do with Bolsonaro. It's either fake news or it's in fact left-wing elites doing something. How do you design a government system that can function with those 40%, which is one reason why I suggest, go back to your original question about politics and law. In the long run, I don't think you can do this by politics. By law. Rather, we have to figure out how to mobilize people on their better angels. So it turns out that people get mobilized in different ways. They get mobilized because they're white. They get mobilized because they're workers. They get mobilized because they're Catholic. In a well-functioning constitutional democracy, political movements successfully mobilize people on the basis of constructive identities. And worker is a constructive identity. Being white isn't. But that's a challenge for political movements, and less, I think, a challenge we can deal with by law, because if there are 40% who say are mobilized by a white identity, that's going to be a problem even when Donald Trump goes away. I see there's a question on constituent power.
Yeah.
Which, by the way, two friends of mine, for the latest people, Yaniv Rosnai and Gary Jacobson just came out, just got my copy on constitutional revolution, which is a wonderful meditation, particularly with Yaniv, on constituent power. mean, one question is, we can all pass a qualifier exam on what constituent power is. It's the power of the people to make fundamental law for the nation. But once we give the short answer, it's very difficult to figure out what we've actually said, because the people don't exist as an abstraction. They are always organized in some form or another. And one of the things we know as political scientists is all forms of organization include some things and exclude other things. So all forms of organizing the people are going to put some people's concerns at the center and other people's concerns at the margins. So in the United States, we have a very fluid constitution, and our rhetoric is not redo the Constitution. It turns out, who knew? The Constitution is on our side. You know, James Madison may have worn a wig and owned slavery, but it turns out once we really understand James Madison, he would agree with me on everything vital. And that's our form of argument. But it turns out for my argument to work, I have to mobilize a lot of people. I don't mobilize them in an 18th century way as the people out of doors, that in some ways a constitution is simply a battleground which has the rules, and whoever organizes best wins. But that's why I think in the United States, since we don't tend to organize outside of the Constitution, we don't have much reference to constituent power.
Mm-hmm. Thank you.
Thank you, Professor. Is that all? Yes.
Please note, I'm going to type in my email. For those who have other questions, I'm always happy to answer questions. As I said, getting academics to speak is easy. Getting them to stop speaking is far more difficult.
Professor Margraber, thank you very much. And I should say that I'm working, trying to elaborate a research project, and it's very probably that I'm asking you some questions next week.
Happy to answer.
Okay, thank you again, and thank you everyone for being here with us.
Thank you.
Thank you, all of you. It was really terrific.
Okay.
Thank you. Bye-bye.